go for the ride. But
Sure.
so I thought that let's meet at like let me sit like a professional like you only on table and chair along with my these small babies.
Sure, Alok.
Okay, Nilesh,
They
thanks.
don't seem to be small babies. So by any standards, they don't seem to be small babies.
You are right. Physically, they may be not, but when we look them mentally, then basically they are like small child only, and they behave in
Okay.
the very same way what any other small pet like a dog or a cat behaves with the owner. Just see, when I got a little of this green hay for them, they surrounded me, right? And
Wow.
now, and they won't harm the owner also. Krishna, play. So you just see, it's coming here for this hay.
Okay. So now Krishna is the one to whom you are giving hay now.
Yes. This is Krishna, and this one is Zenyatta. So you can see it will come, and I'm not afraid of her, and she may eat anything from me. So, but
Sure. Wonderful. Wonderful. And where is Brandy? I don't see Brandy out here.
Brandy is standing there because she is the troop leader, most ferocious among all of them. So
Okay.
she when we keep everyone in the small ring, then she runs around and tries to, overpower other horses. So we have kept her tied up to a place.
Okay. Okay. Great, Alok. Nice to be back with you.
Yeah, thank you, Nilesh. So, Nilesh, thanks a lot for your time on this Sunday morning. Again, we are back to discuss some of the very important issues, points, aspects which this new Income Tax Act 2025 is going to get for us. Uh, it's about the most important thing. What any Indian who is carrying out business with any multinational company, any non-resident, any offshore investor, means any transaction which an Indian taxpayer is carrying out with the offshore person and has to make some payment to that non-resident, to that offshore person. It's not a very simple task that I can just go ahead and make the remittance through my bank. There are requirements of certain documents which are required to be fulfilled. Only then the requisite payments can be made. Why those documents are important? Because the Indian resident has to make a withholding of tax, getting a correct characterization of the nature of payment, withhold the tax, fill up those documents, and then make the payment. Now, that non resident person who is rendering services from abroad, if is rendering services from abroad, would be taxable in India. But uh, thanks to the beneficial provisions under the tax treaty, the non-resident is free to take benefit of the provisions of the tax treaty and have been taxed at a lower rate. But to do that, the non-resident, of course, we all know, has to satisfy the condition that he need to be tax resident of a foreign country, of a different nation. Along with the tax resident, he needs to make a proof before the government of India that he is a tax resident of that foreign country. There are requirements of residency certificate, but in addition to that residency certificate, what we call as TRC, there is an additional requirement to fill in form 10F if in case the TRC doesn't contain all the particulars what a TRC should have. The purpose of filling up this 10F is that the government of India or the Indian tax authorities get a complete details of the non-resident, whether he is a tax resident or not, what kind of services he is rendering from abroad, his other contacts details and all, so that they can very well make an assessment if in case it's required to bring to book to analyze whether the person is taxable or not. Now, when this new law is coming up, it also contains the very similar provisions. But of course, as we all know, it's a new law. So the name of the forms, the rules have been changed. So the new form which is coming into place in place of 10F is called Form 41. The TRC remains the same, but there is a new form. We may call it old wine in the new bottle, but it's exactly not like that. There are much differences in the requirements of 10F and the requirements of Form 41, which I am sure the non-resident taxpayers are going to get a bit impacted with they would be requiring more clarity around it. So Nilesh, here it's very important for us to get your thoughts, views and analysis how this new form 41 is, how different it is from the form 10F, what are the lucidities or what we call ease of doing business aspects have been considered while drafting this new form, what all challenges could be there when this new form has come into place, and how these challenges could be overcome by making some representations before the Indian revenue authorities or Ministry of Finance. So up to you, Nilesh, for this.
So thank you, Alok, for a very detailed background. If I may just supplement, as per the Indian law, a non-resident cannot claim treaty benefits unless and until it has a tax residency certificate. So tax residency certificate is the minimum slash basic requirement. Now, if the TRC does not contain any of the five details, then in that situation, the non-resident is required to submit what you rightly mentioned, Form 10F. Which are those five details that ought to be contained in the TRC, in the absence of which 10F has to be filed? Number one, what is the status of the non-resident? Is it an individual, company, firm, etc.? Second, what is the nationality of the non-resident, or what is the country of incorporation of the non-resident? Third, tax identification number, which is equivalent to what is the PAN number in the country of residence. Fourth is the period of tax residency stated in the tax residency certificate. Many foreign countries have Jan to December as their tax year. So this is what has to be contained in the TRC. If the TRC is silent, then 10F has to be submitted. Lastly, what is also required to be submitted, or what is required to be contained in the TRC, is the address of non-resident in its country of residence. If any of these five details are not present in the TRC, then 10F has to be submitted.
Okay.
Now, the Indian remitter should have TRC plus 10F to be able to evaluate applicability of treaty benefits. This is not just for services, but even for import of goods. So assuming if a non-resident has exported goods to India, the non-resident doesn't have any place of business in India, doesn't have any agent in India, but the non-resident wouldn't like any withholding tax. Because of this, the non-resident will have to submit TRC plus 10F to the Indian remitter. Once the Indian remitter gets this, then the Indian remitter will make the remittance without any TDS for the goods that have been purchased. As you rightly mentioned, this requirement of 10F plus TRC is also applicable for import of services, import of IP. It can be anything for that matter, for which remittance has to be made. On occasions, withholding tax is not applied depending on the treaty. On occasions, withholding tax may be applied at the rate which is mentioned in the tax treaty. Usually, tax treaty provides for a lower rate as compared to the domestic law. Having said so, there are certain critical changes which are now being made in 10F. So, in the revised avatar of 10F, which is Form 41, it is provided that communication address should be mentioned, and such communication address is not just the overseas address. It is required that the communication address in India should be provided. Now, the question that arises is, when for so many years 10F did not contain this requirement of Indian communication address, why is this requirement now suddenly there in form number 41? Because as I mentioned in the opening remarks, many times non-resident doesn't have a place of business in India.
Right.
So how the non-resident will provide an Indian communication address? Is it that the non-resident is expected to appoint a chartered accountant or a lawyer whose communication address will then have to be provided? So all this create ambiguities, and hence it is desirable that overseas communication address should be allowed to be provided in form number 41.
Nilesh here would like to seek one clarification on it. What I understand, there is no monetary limit for any of these requirements under the new Form 41. So a doubt comes to the mind: what would be the fate of a small service provider from, say, US, who is providing some kind of technology or some kind of engineering advisory, right? A small service provider, some website designing person. Although India is a hub for all these activities, but still. So are all those small service providers whose services uh, businessman in India is seeking required to obtain addresses in India without any
That's a good
monetary
question,
limit?
Alok. I agree. I agree. So, Alok, 10F does not, 10F as well as form number 41 doesn't have any minimum threshold for submission. So, any non-resident who is providing services to India, IP to India, of howsoever small amount, is required to provide TRC slash form 10F and 41 before availing treaty benefit. So, if assuming form 41 gets notified in exactly the way it has been now proposed, then in that situation, any non-resident, in your example also, will have to provide an Indian communication address. And this is going to create practical challenges, particularly for those non-residents whose operations are pretty insignificant.
Right, Nilesh. So that's going to be a challenge for all of them. But I'm sure that
Correct.
the revenue authorities and Ministry of Finance would be thinking on it. It's always good to start from more and then to settle down where everyone agrees on the practical aspects.
But, but interestingly, on this, I should mention that form for permanent account number, the application form for PAN, does not require an Indian communication address. So, assuming if a non-resident applies for PAN in India, doesn't have a place of business or doesn't have a communication address in India, it's fine. So, communication address in PAN application form can be an overseas one. So, it is quite surprising that an Indian communication address is being sought in form number 41.
So, Nilesh, I think it's something that we are seeking, that all the whole world should register in India, have some place in India, and then provide services to us. So that we become a hub. It's a kind of attracting more from overseas. Basically, seems to be, as a very layman businessman, I'm talking right now.
So look, yes, we want to attract foreign investment. We want to attract GCCs, data centers, all of which that we discussed in our previous episode. We want investment in Gift City. But at the same point of time, here we are talking about non-residents who do not have any place of business in India, who may be providing any services, who may be providing IP, or who may be exporting goods to India. Certainly, such non-residents will not want any procedural hassles.
Yes.
Least of all, appointing a power of attorney holder whose communication address is being taken for the purpose of Form 41. There may also be issues that I may appoint, say a non-resident can appoint, say a chartered accountant whose communication address is being provided in Form 41, but the chartered accountant is not appointed for lifetime. The chartered accountant may, say for instance, be for 2 years, after which maybe the non-resident can appoint, say a lawyer to be his Indian representative. So then what will happen to the communication address of the CA that has already been provided for?
Right. And Nilesh, here address brings to the very interesting PE aspect always, right? In case of small service providers, definitely, and the discussion around the PE also would not be attractive. But when it comes to medium or large service providers who are actually not coming to India to render any services, they may not be
Correct.
satisfying any of the PE conditions, prima facie. But because of some address being provided, probably a probe would be made by the revenue authorities to see that do they have a place of business in India to be taxed at a higher rate than the rate what is being taxed right now. So even if revenue authorities won't proceed with it, I'm sure, but still it will be a kind of a stress point for any non-resident who is rendering something more than a very basic service. So this is something
Correct.
which is a challenge.
Correct. Correct, Alok, and you are absolutely spot on. So there are non-residents who have affiliates in India, and assuming the address of, say, the affiliates is provided in Form 41, then that creates some bit of, you can say, fear of the unknown
Yes, yeah.
in terms of whether any inquiries can be initiated for permanent establishments. But certainly, I have seen at the same point of time, I have seen that if any chartered accountants or lawyers are kind of appointed in the power of attorney by the non-resident, and addresses of such professionals are mentioned, then typically I have not seen investigations
Mhm.
by the Indian Revenue. But yes, it cannot be ruled out. The best course of action perhaps could be to allow a overseas communication address.
Yes, the way it has been very efficiently done till now. We have been able
Correct.
to attract all the investors, all the technology services what we have required, which has actually helped us to build a nation now. So I think it can be continued, and definitely government will give
Absolutely.
some positive
Great
thought
point.
on this part. So Nilesh, with this week we come to we have discussed on the address part. Uh, what are what are the industry concerns which you think would be there right now, which should be addressed at this draft stage itself? What are your views on this, Nilesh?
So, well, form number 41 requires uh, mention of contact number of non-resident. Now, again, this is something new which we have not seen in Form 10F. Now, as you very rightly mentioned, Form 10F has worked wonderfully till now. There has been no issues for the industry as well as for the government. So, why now have suddenly a new requirement for contact number of tax residents, particularly because of the fact that the tax identification number is already stated in the TRC or in 10F slash Form 41. So now why is a contact number required? We have seen situations wherein overseas contact numbers are not accepted in e-utility for PAN application form. So PAN application form also requires a contact number to be mentioned. But on occasions, we have found that overseas contact numbers are not are not getting jailed or are not being allowed to be filled in the PAN application utility. Hence, it may be advisable if the government can allow contact numbers to be optional in Form 41. Alternatively, if it is mandatory, if the government feels no, now we need an overseas contact number, then in that situation, the e-utility for Form 41 should permit overseas contact numbers of any and all countries. Please remember, like we have a 10-digit mobile number in India. Now, that may not be necessary that all countries abroad also may have the mobile numbers
Right.
or landline numbers in the same format as what we have in India.
Yes.
So, it is important that the utility should be designed accordingly so that uploading of Form 41 doesn't face challenges of the kind that we see in PAN application forms.
Right. So, Nilesh, one very important aspect here, which requires a discussion with you, is also about mandatory requirement of filling up of this form 41, even when the TRC fulfills all the criteria which should be there in TRC. As we started our discussion on the point that today the requirement is, if the TRC is not having all the details which are required under the said rules, then Form 10F is required to be filled in. Although I have myself personally witnessed that many tax abiding citizens have just made a kind of practice fine. I have TRC, but still I'll fill up a Form 10F so as to avoid
Right.
any kind of questioning. So, but this is a proactive compliance. But now this compliance seems to be getting compulsory, that TRC should be there and Form 41 should be filed. Your views on this, and I'll provide my views.
So, look, again, a great point that you are raising. So, 10F is optional if the TRC has those five prescribed particulars. Today, we have seen situations wherein, in spite of, say, TRC having all the five prescribed particulars, many companies or non-residents are still uploading 10F on the request of the Indian entity. And why so? Because of the fact that the CPC utility, when it finds that 10F is not appearing, then in that situation, the non-resident is denied treaty benefits. So the e-utility of CPC requires mandatory 10F, even though the TRC has all those five prescribed particulars. So you are right, per force, perhaps all the Indian companies now, as a standard process, insist non-residents to upload the 10F, even though the TRC may be exhaustive. Now, this requirement is coming in the law itself. Form 41 has to be per force uploaded, even though the TRC may be complete in all respects, which I feel should not cause disruption for the industry. Because today, as you rightly mentioned, the Indian companies, as a part of standard process, insist that non-residents should upload 10F, even though the TRC may be complete.
Right. So Nilesh, I think you have already. I think your views and my views are in the very same direction. I think let's support the revenue department. I support the revenue department on this point. Every country has a different format for TRC, but so ideally there has to be one standard document which is uploaded on the portal, so that the revenue authorities have very ease to basically scrutinize the tax residency of the non-resident. We discuss a lot on ease of doing business, but along with that, on this point I think we should allow them ease to scrutinize the tax residency and accordingly take their due steps. So according to us, I don't think it's a kind of hindrance or kind of over compliance which is required to be made.
Correct, correct. Absolutely, absolutely, Alok. As we say that submission of Form 10F has become a part of life,
Yes.
even though the TRC may be complete in all respects. So I think Form 41 is also now going in the same direction. However, Alok, there are some other concerns also which arise. For instance, Form 41 in the verification part requires that the signatory should be competent to verify and submit this form. This is a significant sentence which is mentioned in the part for verification. Now, what is the meaning of competency? Is it that the signatory should understand what is a TRC, should understand the nuances of international tax, or can a business person under power of attorney submit Form 41, even though he may not be having basic knowledge of tax? This requirement was not present in 10F. So in 10F, you used to find situations that many business people who are, say, involved with sales, who are involved in provision of services, they used to submit Form 10F. But now, does it mean that the tax head or a tax manager of a non-resident, is he required to submit Form 41? Again, this is something that will require clarity.
Yes. Agreed, Nilesh. Yeah. Sorry, please.
Yeah. And this requirement seems to emanate from the income tax return. So in the income tax return, whosoever signs the income tax return should also declare that he has understood whatever he is signing actually, whatever is filled up. So is it that the Form 41 also is progressing on the same lines as ITR, that people who submit Form 41 should know what it is dealing with, what are the repercussions, so on and so forth. So again, clarity will help, because today, as a part of the standard process, many times it is not the tax head or the tax manager of the non-resident who submits 10F. It may be somebody who may be dealing with business, supply chain, etc. They might be submitting 10F.
In a sense, Nilesh, it's going to be helpful. Like my personal experience is, if I ask some business person to sign a document, they will then deep dive into it. They will see what the repercussions are. Sometimes there are business exigencies whereby the in-house tax department is being required to, expedite it without getting proper documents from the vendor offshore. But if a business person is going to sign it and he says that I am competent, then that business person is himself going in the first place get all the requisite documentation done from that offshore vendor.
Correct. Absolutely.
So, Nilesh, I think we have discussed almost all the aspects and points which are there in the new Form 41 versus the Form 10F. What do you think, Nilesh, to what extent the points where the industry concern is there are going to be simplified by the Ministry of Finance before these rules are finalized?
So look, the government has sought comments from the industry and professional associations by 22nd of Feb. It is important that the government is informed not only of the concerns that we have discussed, but any other concerns that may exist, say even in the current 10F. because once the form 41 is finalized, it will be difficult to make changes. So this is the time. We have a window of next 3-4 days available to
Mhm.
make meaningful representations to the government. And I am hopeful that the government wants to ensure ease of doing business in India. So many of the concerns that we discussed hopefully should be addressed in the final notified form 41.
Understand, Nilesh. So, Nilesh, I think we are already done with a good discussion around Form 41, the you see going to be erstwhile Form 10F, and what requirements we have from requests which we have from the Ministry of Finance to simplify them. I think thank you so much for this for your time, Nilesh, and it was a very healthy discussion, and I'm sure the audiences are going to be benefited out of the points which have brought forth. And with this, Nilesh, we'll end our today's episode. And very soon we'll come with another topic which is of very prime importance to an offshore investor in India under the light of the new Income Tax Act 2025.